This program is brought to you by Emory University.
It is our great pleasure to present to you the speakers for this week's Georgia Child Welfare Legal Academy. We have with us today Judge Stephen Teske, Karen Baines, and Mary Herman. Judge Teske is a trainer with the National Council of Juvenile and Family Court Judges and is a presenter and keynote speaker on juvenile justice and child welfare topics, including detention reform, school-to-prison pipeline reform, legal representation of children in dependency and delinquency proceedings, diversion, and alternative sentencing, and other related topics. Judge Teske, along with his partners in the school system, police, district attorney office, and others, provide technical assistance to courts and their stakeholders on detention reform and reducing school referrals to the courts and promoting school safety. Judge Teske is the recipient of several awards, including the Judge Romy T. Powell Award from the Juvenile Courts Association of Georgia, the Howard Abels Award from the Georgia Juvenile Services Association, Clayton County NAACP Community Service Award, Clayton County Bar Association Community Service Award. Judge Teske is the primary architect of the Fast Start Detention Alternative Program, which was the recipient of the 2005 President's Award of the American Probation and Parole Association. Judge Teske received his Associate of Arts degree from Clayton State University, Bachelor of Interdisciplinary Studies from Georgia State University, cum laude, Master of Arts from Georgia State University, Certified Public Manager Diploma from the University of Georgia, and Juris Doctorate from Georgia State University College of Law. Please join me in welcoming Judge Teske.
Thank you.
Also speaking today, I'm going to introduce them all up front, and then they'll come up and present. Karen Baines served as the Associate Director for the Institute's Governmental Services and Research Division at the Carl Vinson Institute. She also coordinates the University of Georgia Committee on Outreach and Engagement, which brings together the university's schools, colleges, and public service units to create collaborative, multidisciplinary approaches to public service and outreach. A former juvenile court judge, Ms. Baines combines her experience working with impoverished populations, her firsthand knowledge of the civil justice system, and her current research agenda regarding improving governmental processes through good practice and sound data-driven policy analysis. Ms. Baines earned her BA from Wake Forest University and her Juris Doctorate from the Bolt Hall School of Law at the University of California at Berkeley. Please join us in welcoming Judge Karen Baines. And Mary Herman, last but certainly not least, spent 20 years providing direct representation in neglect cases as a child's attorney in the Fulton and DeKalb County Juvenile Courts before joining the faculty with the Carl Vinson Institute of Government of the University of Georgia. The Carl Vinson Institute of Government serves as the host and coordinator of the Child and Family Policy Initiative, a multidisciplinary effort bringing together various departments and experts across the university and the state to develop public program initiatives and training opportunities that bridge research, policy, and practice on issues affecting children and families. Ms. Herman's recent projects with Carl Vinson include consulting on child advocacy issues with the Supreme Court of Georgia's Committee on Justice for Children, biannual statewide attorney training on child representation, research studies on racial diversity and diversion policies in Georgia's child welfare system, and impact studies of Georgia's pending new model juvenile code. She also wrote and compiled the Child Welfare Attorney Child Notebook for Georgia, as well as monthly appellate law updates on child advocacy issues. Ms. Herman earned her undergraduate degree from Emory University and her Juris Doctorate from Georgia State University. Please join me in welcoming Mary Herman.
Good afternoon. I'm Karen Baines. I'm not Stephen Teske, but I have the distinct pleasure today of moderating this very interesting, very engaging session. And today we're talking about community involvement for children in juvenile court. You've got two phenomenal speakers that are going to be bringing you a great deal of information, but this is going to be a give and take session. And so after each of them presents, we're going to have a robust discussion. I'm going to run around with the microphone. You're going to be able to pick their brains about alternatives to detention, about the issue of crossover youth and youth that are both in the child welfare system as well as the juvenile justice system. This is a really timely and exciting topic because people are looking at this nationally. You know, I was in Washington, D.C. A few weeks ago now at the Justice Department, and we were just talking about the state of juvenile justice, the state of child welfare reform, and everything that's going on. And one of the questions that they posed to me was, so we got this question from the Vice President's staff the other day, and it was this: we've been at this for a long time. We've been working on juvenile justice issues. We've been working on child welfare issues. When are we going to get it right? Why is it that we continue trying to work on this? And I sat there for a second and I said, because we have to. Because we still have children that are coming into the system, because we figured out philosophically that no one system can do it alone. Juvenile court's not going to solve all the problems. The child welfare system's not. The family can't do it alone. The schools can't do it alone. So we figured that out. And now we have some innovative things happening across the country where leaders, like the two people you're going to hear from today, are bringing all those people to the table to do new types of intervention. We've got children that are experiencing a new society. And so if we don't keep pushing the envelope, keep seeking innovation, we're going to lose a lot of those children, and we can't afford to do that. So without further ado, I'm going to turn the mic over to our first speaker, Judge Teske.
Thank you, Karen. It's good to be with you this afternoon. And let me just piggyback what Karen said. Earlier this month, on the 2nd, I was also in D.C., asked to come up there to speak before the Inter-American Commission on Human Rights on this very topic of system collaboration within juvenile justice, and where is our failures, and where do we need to go, and what strategies, and specifically on the topic of the school-to-prison pipeline, the tremendous number of referrals of low-risk kids to the court systems, and the effect of criminalizing them by labeling them once you put handcuffs on, refer them over to juvenile court for things that a number of us, including myself, got in trouble for when I was in middle school or high school, usually middle school, because that's when all our hormones are raging, okay? And then next week I'm going to be in New York City. I was asked to come up there to speak to the board of directors of the Open Society Institute because they are now interested in as far as what they can do to address this school-to-prison pipeline, alternatives to detention. And so when Karen says that, this has really taken the country by storm, it is. I know Michelle Barclay just walked in. Randy had thanked her earlier in her absence, and when Michelle had called me about this, she wanted to know, are you even going to be in town, Judge? Okay. In fact, I have my bag. I want to let you know I have a suit bag over here. I'm not staying tonight, okay? But I am flying out from the airport. I have to be at the law school at the University of South Carolina tomorrow. Okay, let's start. And let's talk about some real basic things real quick. Let's lay the foundation. In terms of systems, American Heritage Dictionary, take a look at that. I'm not going to read it to you, all right? That's why I got the PowerPoint. And you can see how a system is defined by the dictionary, all right? But in fact, when we take a look at the juvenile justice system, I call it a non-system, all right? Because in most of the jurisdictions, when we travel across the country, we find, including in the state of Georgia, that we find a set of individual complex institutions and governmental agencies, each with its own statutory mandates, budgets, authorities, and regulations. But what does that mean for us? Okay, and this is the problem statement. Let's begin with identifying the problem. We find, as a result of systems not talking to each other, that 48% of persistent offenders do not receive help inside or outside the school. And I'm talking about how it affects, if we break these down, let's start with the school system. And there's many more I can show, we just don't have time. But 77.7% of the persistent violent offenders were never placed in class for behavior problems. We find that 2/3 were never placed in special education programs. If we take a look at juvenile justice in respect to mental health, we find that only 15.4% of persistent offenders received help from mental health. If we take a look at it in terms of social services, we find, and what Mary's going to be talking about, that there are higher rates of arrest reported among abused and maltreated children and youth compared to those absent these circumstances. And we have to ask the question, why? You know, what's going on here and what are we doing about it? And so the effects of non-system, when we look at prevention of delinquency, think about this, ladies and gentlemen. The stats, the data show that the first step in any pathway toward delinquency is usually about age 7, as early as age 7. Moderately serious problem behavior began at age 9.5. Serious delinquent behavior at about age 12, and the average age at which youth first came into contact with the juvenile court was 14.5. So we break that down in terms of simple math. 17.5 years elapsed between the earliest emergence of disruptive behavior and the first contact with juvenile court. And the question is, that I pose to you, the query is this. First of all, maybe had we set up within our systems, our independent systems, something collaborative and focused on young people knowing this data, could we have identified some of these behaviors much earlier, therefore by the time they were at 14.5, they would never have to worry about a referral made to the juvenile court in the first place? That's the question. And that's what we're talking about today. Now, I call it the methodology of community justice. I don't have all the circles here, okay? You know, like public defenders. I don't have prosecutors here. You know, there's only so many circles you can put in this PowerPoint thing, okay? So cut me some slack. But I call it the strategic method of crime reduction and prevention by creating formal partnerships between all private and public child service organizations in the community. Now, I know this is you know the Legal Academy, the focus on child welfare, but I want to kind of do a little cognitive restructuring here. Ladies and gentlemen, even on the delinquency side, if we don't do what we need to do earlier on to identify those kids at risk, to address their situation with the services and interventions that we know that work, that can prevent them from coming into the delinquent system, we fail to do it, are we not systemically in an abusive system? I mean, come on, let's expand the definition of child welfare. All right? So I think we need to consider that thought. So step one is bringing the stakeholders together. It all depends on the jurisdiction where you are, and I'm talking about statewide. You've got to take a look at the law. Quite frankly, in Georgia, the way that we are set up by law, it makes sense that if you can convince the judge, the juvenile judge in that jurisdiction, to bring the stakeholders together, it's the best way in Georgia, and I'm going to tell you why, because of this community-based risk reduction statute. You'll find it in OCGA 151110. Okay? So make a note of that. Because what's this thing called? I titled it The Law and Collaboration. Because what I don't understand sometimes is that collaboration shouldn't have to be an uphill battle when you have the law that states as a matter of public policy we're supposed to be doing it. All right? Let me give you an example. Okay, I'm going to be moving over here. Karen, can you hand me that? I forgot to bring the code book. All right? All those in here who are, doesn't matter whether you're law students or not, but if you're in the system like this, this is not to be sacrilegious, but that's our Bible, right? So let's open up our Bible, because it tells us for what authority we have to do what, but there's another side of this. The law as promulgated by the General Assembly, also establishes what is the public policy of this state. It's like budgeting. If you want to know in a particular state agency, really what that agency cares about, just look at their budget and how they spend their money. Same is true in terms of this state, and what do we really care about, and what focus, and how do we do that focus? 1511:10 says, and I'm not going to read the whole thing, it's too long, but I'll just start off that says, any court may, by order established within the geographical jurisdiction of the court, a court-approved community-based risk reduction program for the purpose of, get this, for the purpose of utilizing available community resources in assessment and intervention in cases of delinquency, deprivation, or unruliness. Wow. It says the court may, by order, bring people, and it goes on to say that it says this, that in any jurisdiction within which a program has been established, when a child comes before the court for disposition, any case involving delinquency, deprivation, or the court may order that an assessment be made of the child and the circumstances result in the child being before the court. And it goes on, yada, 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 about assessment. But then it also goes on, okay, to talk about how the court may bring stakeholders together for the purpose of developing, and it has the word in here, protocols, cooperative agreements, to prevent delinquency, to prevent deprivation, to prevent unruliness. And so I challenge anyone to say, first of all, I have to start with myself as a judge. I've been on the bench for 10 years. And when I came on the bench, the question is, what is my role as a judge? Is it just to sit on the bench with a gavel and say and try to do justice from the bench? Well, if I look at the Juvenile Code, which is the public policy of the state that defines my role, it says I'm supposed to bring stakeholders together. Get them to talk. To do what? To prevent. Not just wait for it to happen, which is reactive. All right? Oh, by the way, it's also important. It also provides for sharing of confidential information between stakeholders. That's a whole other issue. Because when some stakeholders have trouble getting together, what do they want to do as an obstacle? Well, I can't talk to you about this because this is confidential, because FERPA says it is. IDEA says it is. Okay? HIPAA says it is. And I'll just make just a little footnote. If you go to the end of those federal statutes, they'll tell you that you can share by valid court order under certain conditions. All right? 34 CFR, Part 99, FERPA, sharing of federal records, 99.31 states. All right? That's one of the exceptions, that schools may, without prior consent of the parent or child, share that child's school records with the juvenile justice stakeholder, provided that the juvenile justice stakeholder certifies, which I do by order, in which you have a copy of them as part of your handouts, all right, that they will not be shared with any other person. Okay? So in that step one, what did we do? Back in 2002, we started developing a cooperative called the Clayton County Juvenile Justice Child Welfare Cooperative, which we have today. That's your structure. I don't have time to go into it, so I can get to some of these protocols and how we use the law to make things happen and to show you the data of the positive outcomes that are happening. And I did not know this till this morning while I was sitting on the bench, and two of our public defender, I say my public defender, we're a team, okay, but public defenders, Mr. Drayton was the one in front of me when he heard me talking about how I was going to get down here because I had to get to the airport afterwards and so forth, and he said that he and Miss Farrar were going to be there, so I hitched a ride with Miss Farrar. But the reason I bring them up is because the public defender, public defenders are so important, as well as prosecutors, in understanding the philosophy and public policy of the Juvenile Code. So in terms of identifying the problems, what we did is we looked at detention decision points. Streets, here are basic detention decision points. When can we detain a child? Okay? Which in a way, when I say detain, I'm also talking on the child welfare side in a sense too. All right? When we think about removing a child, the streets, law enforcement, social services, intake, informal hearing, adjudication, disposition, post-disposition, specifically probation. When we started to analyze our system, we broke it down that way. And this is the way when I travel the country and give technical assistance and meet with over 2 days with other judges and court administrators and probation and child welfare and educators and police, we do this. We literally go down. We get flip charts out. We break the detention decision and we break them down in terms of how do you do it in your jurisdiction. And then let's go back over and take a look at what do you think about the way you do it. Step 3, we then use the protocols to solve problems. Okay? And I'm going to show you how we've done it over the last nearly decade, okay, to accomplish certain things. First thing, in terms of alternatives to detention, is that we develop a multidisciplinary panel. In July, it went into effect July of 2003. This panel includes, they meet three days a week, right before the informal hearing, the detention hearing. Kids who scored high on the detention assessment instrument. They then come in with, they're brought over. The parents are told to come early at 9 o'clock in the morning. They go before this panel, which includes a CPS investigator, a mental health counselor from the mental health department, the Clayton Center, a school social worker. At least one day of the week, the school psychologist is able to show up. It depends on the testing that he or she is having to do in the schedule. Okay? We have at least 2 private citizens who are residents of Clayton County. They've been trained and they've been certified. They've signed a confidentiality oath. They've taken an oath. And they're like CASA. All right? They're like citizen review panel members. We've just created a whole nother arm of volunteers in the court. And they sit there to represent the kids from their community, in a sense, and speak about those kids and remind the bureaucrats that are sitting around the table, okay, that this is the citizen perspective from the community. We have a moderator who's our JDI coordinator. And what they do, their job is to try to get that kid out of jail that day. That's their job, and keep the community safe. All right? Here we have a panel. They're working on a case right now. You see who's on there. Prosecutors and public defenders are invited. They never go because the PDs love it, because most of about 90% of the recommendations seem to be release them. Okay? And they find ways to release them. Now, this has been going on 3 days a week, 52 weeks a year since 2003. These people have developed a culture. All right? Issues identified by community stakeholders. When we got together, now we're talking back at this cooperative. Detention decision point. Number 1, the street level. They said, the community said, we want to talk about all these referrals from the schools. Okay? And we went, we pulled the data, unnecessary filing of minor school offenses. There was a need for early intervention for at-risk children and youth. There was a need to identify special education needs of court-involved youth. We identified that early on. And support school system with the academic and disciplinary issues of court-involved youth. We identified those issues. And so from that was kind of our strategic plan back in 2002, 2003. The first thing we decided to do was to then, after we developed the FAST panel, in terms of alternatives to detention, to address those kids and get services to them right up front that would minimize their risk to the community and allow them to be released. And I would feel comfortable as a judge that I can release them. And by the way, what I don't have here is that we have reduced when I became judge in 1999, our facility, 60 beds, which is still 60 today, had over 100 kids in that facility. They were stacked on top of one another. Today, the Clayton County, the number of Clayton County kids in the RYDC, the Martha K. Glaze, formerly the Clayton County RYDC, By the way, I'm the one who got the legislation that changed the name so people don't think that all the beds filled up down there are all Clayton County kids. Psychology. The average daily population for Clayton County youth is 12.4. 12.4 today. Okay? Yet the recidivist rate among those kids, the kids that we release, we're releasing a lot more kids, has been reduced 50%. Don't tell me it can't be done. So, we did the school referral reduction program. It had three things: to prevent criminal labeling of youth, promote school safety, and to increase graduation rates. What was the theory? Well, the research is not a theory. Research shows it. The more you suspend kids, the more you refer them to the court, the less likely they will graduate. That is a fact. You can look it up. Just get on your Google, look it up, you'll find it. Okay? That's what happened. So that we said we want to do it differently. Okay? So what we did, here's the data. Look at this. Up to 2003. Police are put on campus in 1994. All right, you have about, 40-some referrals. The year before the police are put on campus, look, by 2003, you have nearly 1,200 school-related referrals. Most of those, over 90%, were misdemeanor offenses. Of that over 90% misdemeanor offenses, most of them were disorderly conduct, school fights, disrupting public school. Kids who were saying to teachers, things like, F off and stuff like that, getting disorder, and they were being arrested because the police were there, and police are doing what police are trained to do. So don't go blame the police. That's what they do, right? Okay? It's a systemic problem. Well, look at the felonies, though. No, we didn't see a sharp increase in felonies because there really weren't that many felonies really being committed on school campus in the first place. Hello, is anyone home? Have y'all figured it out yet? Okay, now. So we developed this protocol. Took 9 months to do it. As the judge, brought everyone together. Now, the law in Georgia says that it's the court that certifies the petition and decides whether or not this should be handled informally, diverted, dismissed, admonished, counseled, whatever the case may be. Now, I could have easily done a standing order and said, look, I just want to tell you, I am no longer going to certify these particular type of offenses, whatever I decided I wanted to do. But I decided that was not a politically good idea, number one. But, substantively speaking, it wasn't a good idea because it would mean that I would be depriving myself of the expertise of all the other stakeholders in education and law enforcement and mental health and child welfare. So I said, I'm not going to make it easy and convenient for myself. I'm going to make it hard. And so what I did is I brought them all together and I met with them individually first. I know people tend to come when a judge asks. It's not me, Steve Teske, it's the robes, okay? All right? So any arrogance I convey to you is from the robe, it's not from my head, I hope. But believe me, I go home and my wife makes sure that she takes care of that. But nonetheless, brought them all together, took them 9 months, and they came up with this focus act. We're going to focus on these acts only, okay? Afraid, disrupting public school, disorderly obstruction, not felony obstruction, obstruction where Johnny is skipping school and the SRO sees Johnny and says, hey, Johnny, come here, or hey, you, and Johnny takes off and he disobeys the lawful command of a police officer. He's now committed a misdemeanor offense for which handcuffs can now be placed on him. Oh, my God, how silly. But it happens, all right? So we set up the system, first offense, second offense, referral to a workshop, which the court said we would continue putting on. It's a school conflict, a cognitive behavioral-based model. Okay. Third offense, then you can file a complaint. By the way, it's only good for 1 year. Starting the next school term, start all over. Blank slate. You don't get to accumulate this stuff like your grades in college. Okay? There's a picture of us, signing, having a happy moment. Here's the impact of the protocol, ladies and gentlemen. Total school referrals. You begin to see the dramatic decrease. We're talking about you know, we're talking about about a 66% decrease, something to that effect, okay, 68%. I have the Hawthorne effect there. I want you to know, during the 9 months that we were talking about this, the police started implementing it. They began to realize that what we were teaching each other made sense. And so the police, as they were coming to these monthly meetings, which we would be meeting sometimes 2 or 3 times a month at first, okay? And they would go back to the school and stop making referrals on some of these kids. It was already happening before we even signed the protocol. Misdemeanors versus felonies, look at that. Most of them, as I said, were misdemeanors, but the felonies started to come down. I'll show you in just a moment. You know why? Because the police were given more discretion, and they started to apply the warning to low-level felonies. Like terroristic threats. What's a terroristic threat, right? I'm going to kill you. How many middle school kids say that? Okay? Right? Is he going to kill him? No. Okay? You know, but now with Homeland Security and all this other stuff, we better be careful because, you know, all right, I mean, he may be a threat to national security. By God, we might have to put handcuffs on him. All right? I know I'm embellishing this a little bit, but it's fun to do it. I'm going to take a little liberty here and there, okay? Detention rates on school referrals. It affected that. The detention rates fell dramatically, okay? Impact of protocol and other JDI programs on total referrals. We had a slight increase in 08 because there was this gang-related activity. There was this gang task force. It's okay. I've talked to the police about that, so we're going to see that come down. But protocol sign, you see the total number of referrals. In fact, the referrals fell so much, and I remember it was about 2-3 years ago from AOC, I get a call saying, Judge, your referrals have fallen by 1,400. Is there a mistake here? Because you know how we have to report to the AOC and you do that annual report? No, that's what's happened. Okay? Impact of protocol and other efforts on disproportionate minority contact, DMC, reducing racial and ethnic disparities. We see again a tremendous decrease in the number of youth of color being brought into the system, which is a horrible problem in this country, by the way. The country, the free and the brave, and the number of youth of color that we still lock up. And I would say in many cases indiscriminately. In other words, what I'm saying, we just don't care, but we do it. As a result, it becomes discriminative. The SROs as an effect, get this, you know what the SROs started doing? They started, at the end of the year, they came back wanting to make changes on the warning system to give them more discretion. They said, hey, Judge, can we add a box to this? What if we don't want to send them to a workshop? What if we just want to give them another warning? We know the kids. We're now getting to know the kids more because you know why? We're now more on we're on campus more often. We're not having to haul these kids down to your court every day, 4 or 5 times a day on school fights and things of that nature. Then they said, look, does it have to be the school? We want to make. What if we have 2 kids in a fight? Can't we just get them to mediate? Will you be able to provide that? Our mediation department, our mediators now go to the schools and mediate on school campus for the convenience of the parties. Whatever happened to customer service? Okay. I told you about, I call this the residual effect, non-focus acts. These are the felonies. Look how many of the felony offenses have gone down, even though the target was only on misdemeanors. On school safety, you want to hear something really interesting here? If you decrease minor school referrals, you're going to increase the presence of the police on campus. When you do that, you increase their ability to collect intelligence. What's going to happen? They're now, the police are, you know what the police are telling me? And look, 2 weeks ago I was in Columbus, Ohio, met with over 100 of their stakeholders from the Director of Public Safety, their Superintendent of the School Systems, all their administrators, all their SROs, mental health, all of them were there, and I brought the chief of my police department, Chief Turner. And this is his turn. When we're here, he gets up and he talks about this, okay? He says, I'm going to tell you what's going on. My SROs are now engaging the kids. The kids no longer see them as the enemy. They now intervene on the kids' behalf. They use the warning, and they get information from these kids. These kids are talking to them where they wouldn't talk before. As a result, what happens? We increase school safety because we can now get things like this right here came from a student. During a warning process, how can you help me, young lady? I'm going to cut you some slack. I'm not going to put handcuffs on you. I don't, da-da-da-da. We got to keep this school safe. And the girl said, well, there's this house right down the street from where I live. I know they're selling drugs. They do surveillance. They get a search warrant. You see assault weapons, $70,000 cash, over 2 pounds of marijuana. By the way, I could show you a lot more pictures. I just don't have the time. I could tell you the story how a year and a half ago we averted a Columbine incident where 2 kids got into a fight. SRO brings them in, talks to them, says, I'm just going to give you a warning. You don't need to go to jail, da-da-da-da-da, and then gets in that thing about any way you can help me, by the way. And one kid says to the other kid, well, should we tell them why we're not going to school tomorrow? And this is, I can't remember which high school it was right now, but I probably don't need to name it anyway. But the bottom line is that the kid says, yeah, and says how there's 2 kids that were going to, that they said they're going to shoot up the school tomorrow. Well, they didn't have enough for a search warrant, but they went out to the house, knocked on the door, mom answers, mom gives consent to search, goes under the bed, finds 2 assault weapons, ammunition, blueprints of the school with numbers as to where they're going to go from one place to the next and with tomorrow's date on it. Chief Turner will tell you if this were before the protocol, we would have had dead kids the next day because in the protocol, before the protocol, the SRO would have put handcuffs on them, not talked to them, not engaged them, would have taken them down to RYDC, and which the kids would have been happy because at least I won't be in school tomorrow to get shot and killed. Okay. And they were not going to rap because they don't feel comfortable because of the way the police treated them. Sergeant Mark Richards says, schools are a microcosm. He's the head of the SRO unit. Schools are a microcosm of the community. If you want to know what's going on in the community, ask the kids in the schools. All right? So, look at weapon charges. These are DF weapons, guns, knives, blades 2 inches or more, box cutters, knives, straight edge razors. All right, those stands for which is a DF, 1 to 5 years in a YDC, a judge could give a child for that, okay? Now, there's no discretion here, ladies and gentlemen. This is a static factor. Do you understand? This is zero tolerance stuff. By law, this agreement we entered into could in no way tell a police officer you cannot bring the child down for this. These things have to be reported. So the question is, why is there a 66% decrease in the number of weapons? The police will tell you it's because the kids are telling us about the weapons. We're actually going off campus and we are getting the weapons because the kids are telling us. Gee, seems kind of smart to me. But no, you know what we want to do? Traditionally, what do? We want to get tough on crime, so we interpret tough on crime as doing what? Locking people up. Not engaging them, not trying to figure them out to get information, to solve more serious things. I like to think that we're just smarter. Avoiding a tragedy immediately. This is what I always grab chiefs of police when I go across the country. What do you think will happen if a person comes on school campus with a gun while your SRO is at intake booking a student for a school fight or disorderly conduct? How embarrassing is that going to be? Let's put things in perspective. How about this? Want to talk about child welfare and the effect? How abusive it is. We know from the research, right, the more you suspend, the more you refer, the less likely you're going to graduate. Look at this. Since we entered the protocol agreement, and what I don't have time to go in with you is that the school system asked us to help them develop graduated responses as an alternative to the suspension. Our juvenile court actually has a suspension center. We actually go in, we help that we send our mediators down there for non-court involved kids as part of our prevention plan. All right? As an alternative to suspension. So we're now keeping kids in school longer. Look at the increase in graduation rates. Notice, now, what I don't have here, and I'm going to have by the time I go to New York City, is you have a decrease in graduation. It bottomed out at 58%, where you see right there 2002, it bottomed out at 58%. We had a decline in graduation rates when SROs were put in the schools because we were referring the kids, more kids were being suspended as well. Gee, go figure that. School-based probation. We did that for the purpose of improving academic performance of court-involved kids, reducing school disruption, and supporting educators. You can see right there, how we handle it. I'm not going to go into the particulars with that. Again, you have the order. It's in a handout. It is a community-based risk reduction order. It outlines it. All right? Quad CST, the Clayton County Child Study Collaborative Study Team. It's a single point of interest. It is Clayton County's system of care. It is by which they meet every week, and any of the system member stakeholders, whether it be DFACS, the school system, mental health, can refer a child at risk of getting a referral to the juvenile court to develop an action plan in which all the stakeholders are involved in working that plan. All right? Our deprivation protocol, how to minimize kids entering foster care and promote reunification involving focus acts. Now, essentially, this is where I'm coming to an end because I want to begin to segue into what Mary's going to be talking about in terms of crossover youth, okay? And for us in Clayton County, we identified, earlier on there was a problem, with you come into the court and you see a kid who, let's say, was in foster care or is in foster care. And even still, you could broaden the net a little bit and say, well, here's a kid that has a history. What we are now finding out, because he's been identified in the delinquency, been brought into the delinquency system, so through our assessments, we realize he's been seriously neglected, okay? And needed services earlier on to address that. And to what extent that sometimes the neglect itself is the cause or some precipitating factor of delinquent conduct, right? Okay? And so we developed this protocol to address that, all right, where now our Clayton County DFACs, as you know, they're involved in the FAST panel, they're involved in the Quad CST. I have no problem with DFACs. If I have a kid that doesn't need to be in detention, we can't locate the parents, there's a caseworker there, even if it's 2 o'clock in the morning, down at the RYDC, picking the kid up, okay, and putting the kid in the shelter care while looking for the parents, okay? I mean, I could keep going. I don't have the time. I only have like 3 minutes left. I do want to close, though, with that 3 minutes. And with Mary getting up here, she's going to be sharing with you an approach, and that is, and I'm familiar with it, and it's an approach that for some time we've needed to address this particular population, who's, in my opinion, has been abandoned because the system, this non-juvenile justice system or non-system where what happens is that kids come into court, they're in foster care, and it's real easy for the system because it's so overloaded. And I'm not here to indict whether it be a probation officer in juvenile justice or a CPS investigator or case manager in child welfare. Sometimes we do things based upon what the system and the demands the system has put on us. And that's why we have to deal with the system first and work to correct that system. But it's real easy for a DFACS worker to say, it's no longer my kid. He's now committed a juvenile act. I'm now turning him over to you. It's easy for that to happen, okay? And the system has to make it easier for these caseworkers in both child welfare and juvenile justice. It's so easy to want to blame personalities. We got to stop blaming personalities. It's hard. It's hard for me to believe that people get into this business, you know, and they do so for money, number one. No. I believe they do it because of their heart, because of their passion. But I believe, though, this system takes a lot of that passion away. And we need to deal with the system. It is broken. And we got to make it happen. Thank you very much.
The preceding program is copyrighted by Emory University.